So the rules of evidence themselves have really very little to say about privilege, but there are two rules that relate to them. So I want to go ahead and lay those out for you. Rule 501 just basically says, look, there are these rules that have long existed, these common law privileges, doctor, patient, lawyer, client, priest, penitent. They're out there, they exist, we're not getting rid of them. Refer to them. There are also statutory privileges that exist, and if there's anything that arises under the Constitution, well, that's in here too. 501 just says these things, they're out there. Now, 502 lays out some very particular rules about the attorney-client privilege, and largely this will come up during the context of discovery. You are handing over 1 million documents to the other side, they're handing over 1 million documents to you. There's something in there that is privileged, and the question is, what's the consequence of that? So Rule 502A says if during any kind of a proceeding, a federal proceeding, or you're answering an inquiry from the SEC or whatever, if you disclose a document that is privileged, does that relate to other documents on the same topic? No, not unless the disclosure was intentional. You actually wanted the SEC or the FEC to see what was in that document. You were affirmatively offering that. And then even if you were affirmatively providing this document, any other documents that might thereby be free from privilege only would be those that are related to the same subject matter, or finally, if in the interest of fairness and completeness, to fully understand document one that you waived, then we're also going to have to bring in this other final document. So this is a very narrow exception and suggests that like non-intentional waivers have very limited consequence. They are limited to the document itself. So basically, if you want to offer one piece of paper that's otherwise privileged that exonerates you, then we're only going to have to bring in other things that are related to this very same thing and that offers context for it. That's the only time that disclosing something that's privileged will lead to the waiver of privilege for other documents. That's 502A. What if you disclose the document and you say, "Oh, sorry about that. That's not what I meant to hand you. Please don't hold this accident against me." Well, the law is very forgiving in this way. And I think it's a recognition of just the scale of modern litigation. If the disclosure under B was inadvertent and you took reasonable steps to prevent it from happening, and then you took reasonable steps to rectify it, you sent notice, you said, didn't mean to do this, this is how it happened, then please send it back to us. Then the disclosure would not you could actually pull back the disclosure that you inadvertently made. And in fact, you'll see at the bottom of a lot of lawyers' fax cover sheet, if you are not the intended recipient, please destroy this and call the law firm. That's part of the reasonable effort to prevent an inadvertent disclosure. So then, what if in a state proceeding you disclose a document? Is it then fair game in the federal court or statement or anything else you would disclose that was otherwise privileged? If you disclose something in federal court, it's not going to be waiver in state court if what you did in state court did not constitute a waiver in federal court, or if that disclosure of the document didn't constitute waiver under state law. So let's say you're in Pennsylvania, you hand over a document, or a document is somehow passed among the parties. If that disclosure does not constitute waiver under federal law, if that disclosure does not constitute waiver under state law, then it neither comes in the state proceeding or in the federal proceeding. So it has to be a waiver under the state proceeding where it's occurring. And then it also has to be that what you did would have constituted a waiver if it were in a federal proceeding. So if either the federal or state court would have interpreted what you did as a non-waiver, then any disclosure of a document or a statement or whatever in state court would not then waive the privilege for that information in the federal court. A federal court can then order that when whatever you turn over in this proceeding is not a waiver of whatever privilege exists in another federal proceeding or in a state proceeding. This would be a protective order that the federal court is allowed to grant that would prevent anything that's disclosed in this proceeding from, by virtue of the fact it's being used in this proceeding, being used in either another federal proceeding or in a state proceeding. And then the final one, and this comes up quite frequently, parties' agreements. And, as much as litigation can sometimes feel like war, it's in the interest oftentimes of both parties to have very, very robust rules protecting attorney-client privilege from accidental disclosure. So very often, the parties will say, look, we're going to give you a whole bunch of documents that you're asking for, and vice versa. You might make a mistake in this. We might make a mistake in this. Let's cut each other a little bit of slack here and say that if you accidentally send me something, then I'll send it back to you, and vice versa. And we're not going to try to enforce a rigorous waiver of the privilege in the event of accidental disclosure. This is a very common, frequent thing that happens in the course of civil litigation, these sort of parties' agreements about the nature of the attorney-client privilege, because it really is in the interest of lawyers to ensure that the profession protects the statements of their clients. So it's kind of an institutional interest that every lawyer has, that we want all of our clients generally to feel confident that the things that they tell us won't be waived when some junior associate accidentally includes something in a file of 400,000 documents, that the state secrets won't be therefore open to all prying eyes in the future. So those are the rules that relate to the limits of attorney-client, or limits of waiver of attorney-client privilege under Rule 502.